This is your attorney, Jiwon Lee. Many were shocked and mad about the Hanshin University deportation incident, and there are some counter-arguments that the students are also responsible for the deportation. So, let's examine why this situation occurred in the first place. This is about the interpretation and practice of the guidelines for issuance of alien students' visa and stay management. It might be a little complicated, so stay focused. In conclusion, both the Ministry of Justice and the school misapplied the residence guidelines, resulting in all the damages falling upon the international students. The reason the school deceived students into leaving forcibly was due to the Ministry of Justice's residence guidelines. According to the Ministry of Justice's guidelines for issuance of alien student visa and stay management, foreign language students from Uzbekistan need a proof of deposit balance certificate issued by a Korean financial institution in their home country, maintaining a balance of 10 million Korean won for at least 3 months. The Suwon Immigration Office of the Ministry of Justice, responsible for Hanshin University, based on these guidelines, demanded the submission of balance certificates from Hanshin University language students on November 6. However, a significant number of Uzbekistan students did not meet the financial criteria required for domestic residence. In essence, international students residing in Korea must maintain a balance of over 10 million Korean won in an account issued by a Korean financial institution for at least 3 months. However, Hanshin University initially informed students that maintaining the balance for only 1 day would be sufficient. Here, the claims of Hanshin University and the Ministry of Justice diverged. While Hanshin University initially claimed they heard it was 1 day from the Ministry of Justice, the Ministry of Justice argued that they consistently provided the correct guidance. In any case, Hanshin University acknowledged on September 11 that the maintenance period of the account balance was not 1 day, but 3 months. However, despite realizing this, they did not inform students and did not request students to replenish the balance. Consequently, language students used the funds since there was no reason for them to tie up the amounts specified. Some students' account balances fell below the required threshold of 10 million Korean won, leading to the Ministry of Justice's demand for balance certificates on November 6 and the subsequent forced deportation incident on November 27. It is evident that students did not make any mistakes initially. They were merely using the funds as they were informed that there was no need to maintain the balance. However, the university neither notified the students of the change in the balance criteria nor requested them to replenish the balance. The Suwon Immigration Office of the Ministry of Justice issued the visa issuance certification for 24 Uzbekistan international students last August. Based on the certification issued by the Ministry of Justice, the Uzbekistan Embassy in South Korea granted visas to students in mid-September. However, none of the international students met the visa issuance criteria. Most international students had deposited money for 1 or 2 days in July and then withdrew it. The reason international students did not meet the balance criteria was because Hanshin University incorrectly announced during the student recruitment phase that the maintenance period for the balance was 1 day. Hanshin University claims that this announcement was made based on the guidance of the Ministry of Justice. Later, Hanshin University realized the initial announcement was incorrect and urgently corrected it to inform students that the maintenance period for the balance was 3 months in September. Most students who had deposited money for 1 or 2 days in July hastily replenished the funds in September after receiving the corrected announcement. According to the guidelines, the Ministry of Justice could not issue visa issuance certifications to these students because they did not comply with the regulations requiring a balance of over 10 million Korean won for 3 months. during the certification issuance stage. However, the Ministry of Justice issued visa issuance certification to international students, bypassing the guidelines. Subsequently, on November 6, the Ministry of Justice again requested balance certificates from international students. According to the Ministry of Justice guidelines, the balance of study expenses for international students should be maintained throughout their stay, and the Ministry of Justice can verify this at any time. However, demanding balance certificates from specific country international students studying at a specific university in Korea is very unusual. Ultimately, among the 24 international students, only 2 could meet the balance criteria. Fearing the disadvantage the school would face due to the students not meeting the criteria, Hanshin University deceived students, loaded them onto buses, and sent them home on pre-booked flights. While the school bears major responsibility, there are fundamental problems with the Ministry of Justice's approach of implementing a blunt policy. It is essential to consider whether increasing immigrants while transferring the responsibility of their management to schools and focusing on impractical aspects such as balance certificates is genuinely helpful. The policy of judging the suitability of residents' qualification based on factors like maintaining a balance needs thorough evaluation. The key point is that the school has no authority to force international students to leave the country. When students are expelled or their visas expire, the immigration office should advise or notify them to return voluntarily. First, criminal law perspective. In this case, false imprisonment, coercion, and inducement. The situation involves the use of private security personnel after students were placed in a car. This can be considered a de facto imprisonment and could be termed as coercion for the purpose of transferring individuals abroad for the benefit of the school. A crime of forcible actions and threats. The university illegally confiscated the students' mobile phones. A crime of fraud. While it is true that many students did not meet the financial criteria for the balance certificate, they were not considered as protected or lost their residence qualification at the time. Therefore, even if they went to the immigration office, there was no reason for the schools mentioned prison. Even if they lost their residence qualifications, the principle is that the Ministry of Justice advises students to voluntarily leave. It is challenging to verify the accuracy of the information provided by the school to students inside the bus. Second, in terms of civil law perspective, it is possible to claim damages against the school for unlawful actions. Also, the private security company that monitored students up to the airport also bears liability for damages. Therefore, the school must compensate students for all damages and losses incurred due to the forced deportation. Moreover, considering the initial mistake by the Ministry of Justice in issuing visas, the Ministry of Justice also has national compensation responsibility. While there can be arguments that students could not have originally obtained visas, but due to the misinterpretation of guidelines by the Ministry of Justice, the visa was issued, and once the visa is issued, it is considered valid. Implications. The incident that occurred on November 27, 2023 was only revealed later through Hankere's exclusive report on December 12. Currently, Hanshin University under investigation by the local Osan police station based on reports from international students. The Uzbekistan embassy, which received the tip-off, is gathering specific details from deported students. Hanshin University, the Ministry of Justice, and others. The National Human Rights Commission has also initiated an investigation after receiving complaints. The key implication of this case is that no private entities have authority or legal power to deport its members, except the immigration office. Even if the immigration office orders deportation, they also notify a procedure to appeal the order. Thus, if we tolerate a case like this, it means giving immunity to private entities even if they illegally deport their members. In other words, it can happen again, and it can happen to you. This is your attorney, Jiwon Lee. Thank you for watching.